doing, we are creating a president with way more power over the judiciary than you find in most peer countries. Uh, so let's look briefly. So, as I said, in Zimbabwe, in terms of 2013, it was public nominations, public interviews, and then the president appoints, right? Now, what we're going to have after Amendment Bill number 3 is that the president just has to consult and then do whatever he wants. The public does not nominate. The public does not get to monitor or watch any interview. And the president themselves, they lack the popular mandate. So both upstream and downstream aspects of judicial appointment have been delinked from any popular legitimacy. The people are not involved at all. It's just the president gaining more power. Now, compared to, I'm going to give you a comparison here to Kenya, Ghana, Zambia, Malawi, okay? Important for us, Zambia, Malawi, these are the ones for which we were briefly in a federation, 53 to 63. Ghana and Kenya, generally, those are respected democracies on the continent. And if you look, and in Kenya, the president is directly elected, and the Judicial Service Commission handles the nominations from the public. I think there's statutory provision for the public to do so. And then there are live broadcasts of interviews. And then the president has to appoint from the list from the Judicial Service Commission. So the public is involved, public interviews, public nominates, president appoints, but based on the Judicial Service Commission. In Ghana, the president appoints, but with parliamentary approval. So you see, it is it's almost checks and balances, different arms of the state. In Zambia, the president appoints subject to ratification by the National Assembly, just like Ghana, together with the legislature. In Malawi, the president appoints with the Judicial Service involvement. Now, if you can see, it's all split that way, right? In the case to be very strong, Kenya, Ghana, where you need either approval from the legislature or, in fact, you're bound by the Judicial Service Commission. And then let's look now at the countries where we say we are moving towards. So we are no longer, we say we don't want the directly elected president anymore. What do those with indirectly elected presidents do? South Africa, Botswana, India, Germany, UK. And in South Africa, because remember, if you're indirectly elected, you no longer have the popular mandate. So how do people deal with that deficit? Well, look, in South Africa, the Judicial Service Commission does multi-stakeholder consultation, particularly in parliament, including with leaders of the opposition, and their public interviews. And the president is fully bound by the decision of the Judicial Service Commission. In Botswana, the court decision, Motumi saying 2017, the president is bound by the Judicial Service Commission recommendations. In India, it's a collegium system where the judiciary almost like appoints itself. The judiciary appoints. In Germany, parliament elects judges by 2/3, a supermajority. And in the UK, it's an independent judicial appointments commission. So you see, the protections are very strong once you go indirect, because the person doesn't have a popular mandate. Where you have, like in Germany, I believe that's the Bundestag, is the actual legislature which is electing the judges, right? India, it's collegium. The judiciary are almost appointing themselves. And in Botswana, bound by the JSC. In South Africa, you are consulting even leaders of the opposition, public interviews, public nominations. And what are we getting in Zimbabwe? An indirectly elected president who is not bound by the Judicial Service Commission. You can't find that anywhere else, right? We are being really inflationary, aren't we, right? We are control. Perhaps we have control for inflation in the economy, but for presidential powers, it's out of control. It's certainly out of control how the powers keep on rising and rising. And we are told this is how we sustain economic development, by taking away independent powers and giving them distinctly to the president this way. Now, I want to say something here by way of analogy, right? Because there's a separate question that is to be addressed. Chief Justice Gounza is now the head of our judiciary. Chief Justice Malaba was the head of our judiciary. Both of them were Deputy Chief Justice before they were appointed Chief Justice. So in terms of seniority, you could have predicted this is the next one who's going to be Chief Justice. So there's a question that people ask. It's a reasonable one, right? That if these are the people we're always going to be appointed, why do we even need these public interviews? And if there's something that is seeping through Constitutional Amendment number 3 bill pretty consistently, is this claim that we need to be reducing costs, economic stability, right? Elections are expensive. These public interviews are expensive. The gender commission is expensive. So we need to streamline, right? It's a very neoliberal logic that permeates through the Second Republic, broadly speaking, but this amendment as well. It's this idea of austerity, right? The economic idea of austerity as, living within your means, almost the eat what you kill philosophy we had when Tedai was Minister of Finance. And it's now migrating into the constitutional arena where we just streamline everything, and when we treat fundamentals of democracy, the judiciary, human rights as luxuries that should be treated not as values that undergird more important outcomes, but in fact looked at in sort of dollars and figures, in something that must be almost like, how do we balance things out? How do we make things cheaper? How can we remove all these niceties in order to ensure that we are saving money? Because that apparently is what is actually costing us a lot of money. Okay, it's nothing to do with foreign travel, for instance. It's nothing to do with the size of the entourages that go at UN events, or would that go to Davos? No, those are fine. The problem is the gender commission. The problem is elections. And the problem in this case, public interviews. We need to be cutting the cost. And if they are always going to appoint their preferred candidate anyway, why must we have this process of public interviews? And I want to address that here, but I want to give a proper analogy before I give a summary of why I think public interviews are important. Now, we have a practice in some parts of the Shona-speaking regions of Zimbabwe where if people are planning to get married, they will introduce their partner to their family before the marriage occurs, right? Sometimes it has to be through the aunt, but sometimes it's directly through family members, but you introduce, so that when the moment of marriage arrives, you've already had this preliminary encounter where you've introduced, this is the person. In some cultures, it involved some exchange of a clothing item. And then there is the marriage ceremony itself, where the families meet, two families meet, and then there is this consent that is expressed over exchange of either exchange of value, gifts, goods, money, or an expression of an intention to fulfill that debt that then cements this relationship that people then call marriage. Now, we know two things. First thing, both those encounters of introducing the person and the actual marriage have got a built-in presumption that the family can reject your partner. Either that initial introduction or the actual marriage, those processes are understood to be formulating communal consent, right? That, okay, we recognize your partner, we accept them, they are part of our family, we accept and we give social legitimacy to this union you are creating. Is not just between the two of you, but between our families, and to actually assign you roles within that broader structure of the family. But we can say no, right? We can say no. I'm a big fan of Oliver Mtukudzi, and I think it was on his Shovi Yangu album, was that 1995, where Oliver Mtukudzi has a song called Mamuramba, right? You have rejected her. I have come to you with the person I want to marry, and all of a sudden you said, she's too dark, she's too light, she's too thin, she's too... So there is, in fact, that cultural conception of marriage and the introduction as not just formalistic, but in fact, including a veto power. In some instances, the mother or others can say, we do not want, we reject your partner, right? So we are aware of that. That's number one. They can reject. Often they don't, right? Often they simply accept, we do want the daughter-in-law, we are so happy. But the fact that it's not exercised doesn't mean it's not actually part of the ceremony and not built in to the power relations, why the son-in-law has to be very humble, why you have to act this way, because you do know there is a background reality that there can be rejection here. There is some consent that is being built. And yet people go through these processes. This is my second point. People go through these processes, but they are not legally required, right? They are not legally required. Not since the Legal Age of Majority Act 1981 and the series of court cases we got. I believe the Perhaps the most relevant one is Katiko versus Muchabayo. I may be wrong about that, but there was certainly that case where Dumbuchena is saying, oh, by the way, because women are now free to contract under the Legal Age of Majority Act, there is no longer need to secure consent from her family or her father for the purposes of marriage. Legally, it's not required anyway, right? And at the point, it was very controversial. It came up in the question and answer time in Parliament, because we used to have that under Lancaster, right? That's what I was talking about last time, that the Prime Minister would need to come and face questions and answers from members of Parliament. And Prime Minister Robert Mugabe famously said, I don't know what the courts are saying, but you want to marry my daughter, you're going to have to pay me the bride price. That's all I know. Why do people continue to pay the bride price? Very expensive, not just to pay bride price, but to bring families together for that marriage ceremony. Why do people continue to even have, those expensive ceremonies when you could just go to court? There is nothing that is more cost saving than going to your nearest court of law and paying $15 or $25 that the court requires, and you are legally married. It's over. Two people have made the decision, right? And sometimes we have an argument about what is a token of appreciation. You want to know what a token is? Go get married at the court of law. You're going to pay like $20. That's a token. The court is going to be very tokenistic in what it asks from you. Just pay about $20, whatever. Bring your witness, sign the papers, and here's your marriage certificate. At law, you are married. Why do people not do that? Even when they do that, why do they also need this other process, more expensive process? Because a lot more is happening during the marriage process. Okay, what you're actually doing, because if you go two people meeting over there, is not going to build communal consensus. People need to know you, people need to recognize you and have an awareness. Because when in fact things go wrong and you are married, you need people who have invested in your marriage. And how do people get invested? By personal contact, by seeing you, by knowing you, by introducing, by visiting. These are real ways in which relationships are created and fostered, such that when the Chief Justice, that is to say, when Chief Justice Malaba, the former Chief Justice, is saying we've respected the people's wishes, I was presented to the people saw me, the people have an awareness of me, okay? And that awareness, you cannot construct it by waiving your marriage certificate and saying we were married at a court of law. But we'll say, yeah, but we don't know you. You never visited us. You never came here, right? We never actually came to your ceremony and met, broke bread, and created the relationship for which you now seek recognition. And so judges need that, right? Because judges are unelected. That's why judges need to be grounded in the people, because judges do not have their own police force or army. They rely entirely on the executive. So if they face undue backlash, they rely on the people. And that's why they need to create a constituency within the people. But how do you create that constituency when you do not campaign as in elected judiciaries in the United States? Well, you have this public interfacing process where you come and speak, right? Just as the marriage partners, you bring the families together and there's an interface. And then in the end, you introduce, they ask in the marriage ceremony, who are you here for? You identify the girl. And then finally, the groom is introduced. Okay, we know them. As a family, we now accept them. This is now part of your home, right? And it's the same for the judiciary. The people see you, right? They see your qualifications. You are sent there, but we know them, right? Some people say, I know personally people who watched Chief Justice Malama's interview and say, I liked him. I liked his confidence. I liked what he said about him. And that is what you're trying to build. And so that's a long way of getting to my point here. And the point I'm making here is the fact that there are 5 things that we derive from public interviews, which we need to hold on to, which we are losing. The first is what I've been talking about here, deriving authority from the people in a visible way. People seeing their candidates, people seeing the performance of their candidates and having that ability to be open and transparent, which would give the ability when Chief Justice Gonzo was asked by Ruben Barrow about judicial capture for her to say, well, we are open and transparent. People were able to view that process of how I was eventually appointed as a Chief Justice, right? So we're deriving it openly that way. And look at how former Chief Justice Malaba in his exit interview on ZBC references this same openness once he's talking about that presidential petition between Chamisa and Mnangagwa. And he's saying, look, I say to myself, there's too much misinformation. So why not just make it open to the public, right? That ethic of making the judiciary open, accountable, public facing, right? And you're not going to get that same ethic once you remove this ability to derive the authority from the people in this visible way. And it seems that, we're not getting some of that live streaming. Now we are losing some of that ethics. So you're deriving that authority directly from the people. Secondly, you're constituting legitimacy, right? We're not just sitting all day wasting our taxpayers' monies. We are creating knowledge within the public. The same way here in the United States, everybody knows, right, that the Supreme Court is not just Chief Justice Roberts, but it's Alito, it's Thomas, it's Kavanaugh, it's Gorsuch, it's Ketanji Brown Jackson, it's Amy Coney Barrett. Why does everybody know them that way? All those proceedings from the Supreme Court, they are streamed audio. You can listen to all the arguments for all the Supreme Court hearings. Whereas in our case, you can't even access. It's a very small courtroom, but there's no live streaming, no audio, certainly no video. So people don't have the knowledge of their judges to build the legitimacy, right? If there was a resource, we're talking about outcomes for people to actually file cases, but if there was a resource for people to listen to arguments consistently, and to not simply associate their judges with the political cases into which they're invested or interested, then people would have a knowledge of the technical basis upon which judges are making decisions, and not the political priors which people project when they read into cases such as Chamisa versus Mnangagwa. So you're constituting the legitimacy. People, they know why this person was appointed, and you avoid the misinformation we were getting about Chief Justice Gwaunza. Some people actually posting on X that he doesn't actually have a law degree, and some people actually believing that. Some people actually having arguments about that, because we didn't have this process of the candidate simply sitting there and justifying herself, and people learning about her journey and experience. So it just happens in a flash that you have a new Chief Justice without people being presented with this person's story, their CV, why they feel they deserve it. And then they respond to questions from the Judicial Service Commission, and you can see how she responds. Like, oh, she's impressive. I do want her to be my Chief Justice. Such that when you see her presented as the Chief Justice, you feel a certain investment, same as if you attend the major ceremony, which you don't get if two people just go to court, or two people, the president just appoints the Chief Justice, it's done. Because that entire process of constituting a public-facing legitimacy is gone. Thirdly, accountability, right? These public interviews are great for accountability. If you have time, most people don't. If you look back at the interviews for constitutional court judges, there are specific judges where the commissioners, and this was specifically Commissioner Noktula Moy, I believe, and now she's no longer a JSC commissioner, where she's asking a specific judge, you had like 4 or 5 judgments, which were pending for like 5 years, 4 years, 3 years. And then in this week, in anticipation of the interviews, you released all of the judgments, right? How can you account for that? And then he had to explain, why have these judgments been pending in a public-facing manner? And you're removing that accountability, right? And that's just one instance where you had these litigants who had been waiting for years. And what saved them? The public-facing nature of the interviews. Now we don't have the interviews. They're gone. So you're removing that accountability for which litigants can benefit. And then in a fourth way, I have already said judges need to build their constituency. They do not campaign. So they at least need to be presented to us in the public for us to know them, to create a distinct form of power. If you think being presented to the public is not a form of power, then perhaps you're not aware of how different forms of power are constructed. Just watch ZBC News, as I enjoy to do every single day. And you will not make a mistake about who is presented to the public every single night. Watch it every night. Who gets the headline? Who is the first story? Who is the second story? Who is the third story? Every night. They don't miss a step, right? They don't miss a step. They know who has to be presented daily to the people to create that form of power in your mind. And the judiciary does not get that every day, but they deserve some presentation to the public to also create their own constituency, their form of power. And then finally, as I've said, this makes the judiciary open-facing, such that when you make these requests for live streaming, then you can have an ethic where the judiciary is public-facing. And you can have real arguments when people then say, hey, the judiciary is captured. And you're like, no, not captured. This is precisely why we have these tools to be public facing, for you to see how I was appointed. In fact, my nomination, you say my nomination did not even come from the executive or the president. I was nominated by a lawyer at a law firm out there, or not even a lawyer, an ordinary Zimbabwean nominated me. So how can you claim that there is capture when the public is involved that way? But it's all gone. We've removed it all. We will no longer have that capacity to actually say it's public facing, the public is involved. And I don't think there's any justification for removal of this public interview process and this process of nominating by the public. It's all gone, right? Now it's just the president, and he just has to consult and is not bound. More powerful, as I've shown, than all the other regional peers.